Hello, loveys. Welcome to a Saturday stream. It is March 22nd, 2025, and we have with us, I couldn't even leave him backstage, he's our guy, the incomparable and our favorite defense attorney out of New York. It's Mr. Mark Bederow.
How are you?
I'm good. How are you today?
Good. Good.
Good. I haven't seen you, Mr. Bederow, since I think in 2024 was our last time that we saw each other.
Could be.
I missed you.
Here I am.
He's here. He showed up for us. And what a week it has been. I feel like every week, Mr. Bederow, I say to myself, it's been like another 7 years, like dog years. It's taking time, right? And this week my head was spinning from the Commonwealth, from motions in limine, from Mass State Police, and from a brand new Bederow Letter. So I want you to you start and tell me all of the things that you want to. Maybe we'll start with motions in limine.
Whatever you want. I'm a guest. I have no editorial input, suggestion, or thoughts.
Well, I think let's start with motions in limine, because we had 2 days last week. We had Tuesday and Thursday. So first day, there was a lot. Second day, there was a lot. And Friday, we got new Commonwealth motions, including attorney-client privileged information. Where were your biggest concerns with the Commonwealth?
Well, the attempt to look through communications of a lawyer and client in the immediate aftermath of some kind of investigation, arrest, retention of counsel is about as offensive as anything can be when you do this for a living. I mean, attorney-client privilege is the most sacrosanct thing in this world. And although there are things that can lead to a technical waiver, to see a prosecutor literally seek to blow it all up, in essence, try to make one of the lawyers a witness against his own client, jeopardize his continuation in the case, which, of course, given this bizarre case and the fact that he's the only attorney of record licensed in Massachusetts, really it would put the whole defense team at risk and stop the trial because the client would have no lawyers. So again, there are common situations where waivers are argued, they're pursued, but to see a prosecutor 10 days before trial, just as the latest lobby in what feels like 30 motions about everything under the sun, seek this information based upon some, by all accounts, not great public statements. Those statements that she made, those are admissible. If they choose to use them, they can. But just because you can doesn't mean you should go to the next level, which is just attempt to blow up the whole case by demanding to know what she told David. And to me, it's all a tactic to just wipe out the defense team and potentially make David a witness against her. I mean, obviously, if there are any communications, if the judge even entertains this, then that would very much be the situation. Now, again, you can say that there was a technical partial waiver based upon, a public statement about, well, I was doing this and my attorney said that, but I don't know any prosecutor who would ever take that and say, I'm now going to go backwards and say, I need to search through every communication attorney and client made related to this alleged crime for the first 3 or 4 days, even if that means wiping out the defense team, even if it means delaying everything. This almost feels personal, to be honest, because the thing that's amazing to me, again, as a part of this, is when this case is over, this is not a prosecutor in the DA's office. This is an attorney in private practice. And I wonder what harm is he doing to himself beyond this case? in terms of generating business when you see that a lawyer has what appears to be that little regard for attorney-client privilege. I mean, it's just, I don't know how that's going to affect him after. I don't know how it's also going to affect his relationship with prosecutors to see the level of aggression in seeking things that potentially could blow up a trial is in a late phase like this. So I don't think the motion is frivolous. Let me be very clear. I mean, I think there were statements made that to some extent do talk about things that are relevant, I suppose, and do relate to discussing privileged communications. But again, just because you can doesn't mean you should. And I don't think that I know any prosecutor who would literally take that action. And the real question is going to be, does the judge want to go down the rabbit hole and literally potentially blow it all up and say, go get new lawyers and see you in 5 months for a new trial? Or is she going to take the more pragmatic view and say, you know what, you have these statements. If you want to use those are admissible. If you think that helps, go ahead. But I'm not going to let this literally at this late stage do that. She could, but you have to ask yourself, why would the prosecution, if they had a strong case 10 days before trial, which they keep telling everyone they're chomping at the bit to try on schedule, lead everyone down a path that would be destined, if he's correct and if he's going to win this issue, which would ultimately just end up delaying the trial for months and months.
And Mr. Bederow, can you explain to us as non-attorneys, like, although Karen made statements, right, to public outlets, and therefore, ergo, it is a technical waiver in a certain circumstance, couldn't one argue that her giving one statement doesn't mean that there's not 90% of other statements that should remain attorney-client privileged, or no? If you open the door, it's all open.
No, I mean, it gets technical. It doesn't, because she said, I spoke to my lawyer and here's what I said or he said, is not a literal waiver of everything and does not allow to, look under the kimono of everything they've ever spoke about or written each other. But what it does is it could be a partial waiver as it relates to the subject matter of the communication that was waived. And of course, the prosecution argument is that the subject matter of the waiver that was described on national TV was this discussion about whether I hit him or not and whether I could be culpable if I did. Now, a judge could also say, I'm not going to literally now just start looking at everyone's communications because there's this speculative belief that there's going to be more there. And there is something unseemly about that.
Right.
Whether it's, again, what I would call a law school violation where, it's a hypothetical and you spot issues and you say, well, this could be a waiver. This could be that. It's a criminal case. It's a murder case. The stakes are as high as they get. It's 10 days before trial. And here we are having these kinds of motions that could delay everything. And, it'll be interesting to see whether a judge, in weighing all of this, is going to be hyper technical or be pragmatic, especially since, the impression everyone is getting is that if the trial does not begin on April 1st, then everyone in the courtroom is going to turn into a pumpkin. I mean, that is basically how this has been being described in the last several weeks and months. No delays. And now here comes this, which would cause a critical delay, because if there are communications that are disclosed, whether they're incriminating or not, it's possible that David would have to be a witness, and you can't be a witness and try a case. I mean, this is the same thing that we've been trying to kick off Ken Mello in the other case for feels like 3 years now.
Right.
Now that's a little different because he was a fact witness. It's a little different, but same idea. Under what they call the witness advocate rule, you can't play both roles. And he also may feel compelled to have to testify if they try to introduce these communications, to put them in a rightful context that are much less harmful than the DA would describe them. So again, really the most fascinating part of this is to see what the judge will do, because all eyes are on her, because if she goes down this path, you could have a serious delay.
And that's so funny you say that, Mr. Bederow, because I would think to myself, generally speaking, she would allow Brennan to go down that rabbit hole and her follow right in suit. However, she wants to be down the case. Okay. And in my opinion, I know that's speculative, but she wants no delays. Like you said, this is, she's hard set on that April 1st. And I think that would be the only prevention for her, is her scheduling.
Well, there's one other wild card here, and this may go under the be careful what you ask for, because you might just get it, which is the testimony at the first trial is pretty clear that when the two state police guys took the trip to Dighton, they didn't just take the car, they took her phone. And that was on the early or mid-afternoon of January 29th.
Right.
And I believe the further testimony was that we turn the phone off or put it in airplane mode or whatever they do. In other words, there's going to be no update on the phone.
Right.
And if it stayed that way, then that means that there would be on the phone anyway, on her phone, a finite timeline where things would end on January 29th. And, if it turns out that that testimony was not truthful and there is information on the phone and somebody did actually look at the phone and the DA has reason to believe there's something there because somebody did in fact look at the phone. I mean, are they assuming there's something there? I don't know. Again, because this is otherwise just, grasping at straws. And their own, well, since disgraced and terminated state trooper had said that phone was out of commission, whatever the time was on the 29th. So she can't really be doing anything that would be evident on the phone. Now, could there be other ways for them to communicate? I guess. Could they email, like unrelated to her phone, this and that? But what happens if it turns out that that testimony was false and there is evidence that it was viewed?
Wow.
Is that worth the trade-off? I would suggest, if I were the DA, no.
Yeah. Yeah.
Because
And that's murky. You're setting yourself up for Pandora's box and we know now, like you said, disgraced former dishonorably discharged trooper Michael Proctor, right? Like, this is the one who said he was looking through the phone, all of that. But would that lead to a potential, maybe misconduct that was going on, or, violations of her rights? And you were going for a slam dunk and you lost it.
Well, and one of the sanctions you might seek is, not allowing this. So again, the other question you have to ask yourself, that this is a purely speculative exercise.
Mm-hmm.
I mean, really don't know what any communications are, assuming there are any. I don't know. This is a very speculative exercise 10 days before trial, and you're focused on this. And I mean, again, I don't know what they claim to have or don't have, but you kind of have to ask yourself, this feels like real small potatoes in terms of gathering evidence if you have a really strong case, to put this kind of effort and energy and potentially delaying the trial and having every single lawyer on the case tossed off.
Yeah, no. And Kate actually asked a question, and she said, if they called Yannetti as a witness, would that, like,
they're all going?
Oh,
because David is the sponsoring attorney. He is the only. No. If David goes, they all go, because any pro hoc attorney on this case is operating under him. He sponsored and tried to sponsor me too, but that's another story. The point is, no, if he goes, they all go. But if David remains a witness and this case gets rebooted, I mean, the other lawyers could all rejoin under a different Massachusetts license.
Yeah, and BL just said, and Alessi too. Yeah, but Bob Alessi is out of state and under
Yeah.
David Unetti's license as well, Lovey.
They could all come back, though. I mean, literally, any Massachusetts attorney who's admitted, who puts in a notice of appearance on this case, can sponsor, out-of-state attorneys who. So, I mean, the lawyers would go, but they could all come back, except for David if he's considered a witness.
Correct. Now, and I'm just wondering, just for my knowledge base, Marty Weinberg is Massachusetts. Would he be able to or no? Because he's appellate.
Yeah, no. He's a Massachusetts attorney. And that is interesting. He does have a notice in the case.
For Jackson.
That's interesting. That could be an end around, actually. But then, the question is he going to be there every day for 2 months and that sort of thing? But
right.
If he does have a notice of appearance in Norfolk Superior, which he does, that is potentially a way to keep the rest. I didn't even think of that. Yeah.
Oh, well, this is why I'm your favorite nurse. Okay, babe. Now, now let's go, if you don't mind. When I was watching Thursday morning, your co-counsel, Tim Bradel, did what I believed was an impeccable job. When I saw the Reed team come in, okay, they dropped it like it was hot. Oh, and I didn't know how to contain myself. I see Aiden sitting there. I see Mr. Bradel, and then Hank gets up. He knows he's in a completely different courtroom within the first 2 minutes with Judge Sisitsky. I say the name wrong. Sititsky.
Yeah.
What is it?
Sisitsky.
Sorry. But there was incredible questions from the bench. There was a lot of and things that Hank couldn't answer. But when I tell you, chef's freaking kiss for co-counsel Bradel, they had a moment, they connected, they almost had a bromance. I know it's not true, but they were laughing together. And then at the end, when we got our motion, or our orders that night from that hearing, it was apparent that it wasn't allowed in full. It was only allowed in part. And what did you make of that order? And, how are you guys feeling after that appearance?
Well, let me start just by, there are certain things about the current open case in which I'm involved. I'll just discuss, what's public is public, but no, it's fine. But look, none of us really believe that client's going to be a witness against Karen Reed. None of us believe anything other than they don't want him in the courtroom and they don't want him reporting on this and they don't want him doing his show. Mm-hmm. So, I mean, look, from our perspective, it's just part of the pattern of stifling his First Amendment rights for the last however long. That is what it is. The next thought is of all the days that the schedule would not permit me to be there, that would have been the day, obviously, to be there. But as far as the practicality of the ruling, the prosecutor in Karen's case is alleging that all of this evidence of supposed intimidation and this and that somehow evinces her consciousness of guilt. And again, initially what he did was just ask for blanket access to the phones. And as Tim properly said, there's nothing wrong with these two people communicating and talking. There's nothing per se wrong if they decide to share information. But the idea that they want to introduce evidence of another person's alleged witness intimidation that purportedly was done in coordination or conspiracy, if you will, with Karen, her consciousness of guilt, that evidence is troubling for the simple reason a grand jury considered that and threw it out. And you have to, but beyond that, and this was described in court, grand juries almost never, with a capital N, never issue a no true bill when a prosecutor asks them to indict and there's no defendant testifying. You know, in grand jury, there's no judge. They use hearsay. It's just the DA giving a very biased presentation of however they want to do it. And, you know, they sought an indictment from grand jurors who knew at that time that Karen Reed was already under indictment for murder and starting trial a month later last year, and that the alleged co-conspirator was already under indictment for witness intimidation. And they looked at this evidence and they said, we're not even going to find this probable cause to vote an indictment. And
if the saying is you can indict a ham sandwich, did they just bring 2 pieces of Wonder Bread?
Yeah, I mean, that's a famous saying from actually former Chief Judge of the New York Court of Appeals, actually. Saul Walkler is the one who basically, you can look that up in New York Court of Appeals, Saul Walkler, who has an interesting, he actually got thrown off the bench for other reasons years later, but that's a whole nother story. The point is, grand juries indict when they're asked to indict 99.99% of the time.
Right.
We didn't do it here. And then you have to go one layer back, which is last year when all this stuff before the first trial came up about the alleged witness intimidation. Both sides generally agreed, well, let's keep it out. And then there came a point where, you know, the DA wanted to use it and they were alleging there was all this intimidation. And again, that it would be relevant to Karen Reed's consciousness of guilt, because of whatever their view of Aiden is, it doesn't matter in a trial of Karen. That is how it's spelled. That's correct. But what Adam Lally never told the judge was that he knew, Canoni didn't know, Karen Reed didn't know, and Karen Reed's defense attorneys didn't know that this evidence that I want to introduce, if the door is open, had already been found by a grand jury to not even support an indictment. Now, that doesn't mean the judge literally would have to say, I'm not going to allow it, but we've heard a lot of lectures lately in this case about candor to the court, and you have to be honest and tell me things and speak accurately. And that was a blatant ethical violation that the DA's office committed before the last trial by not disclosing to the court that when they were going to seek to introduce this evidence, that a grand jury had already dismissed it. But the bottom line is they're trying to do the same thing. They're trying to argue consciousness of guilt, and they're allegedly going to have the right to search a couple of cell phones, okay, for information of alleged intimidation in conversations between these 2 people that relate to the witnesses. Good luck, you know. And number 2, you have to understand, these phones were seized that they're looking at now, that the judge gave them permission in October of 2023. So those phones have had no new data. You're silenced, by the way, but that's okay.
Thank you, babe.
You reminded me of Mike. You know, he does that like 6 times an episode. If
I do it at least twice. Yeah. I'm second place on that.
Yeah, well, you know, but so, you know, these are phones that have essentially been frozen in time since October of 23. Whatever was on those phones prior to October of 2023, they tried to use in a grand jury that did nothing. And in fact said, we're not doing it. So where is this going?
Totally agree. Yeah. So, and again, I apologize about asking like a fool, but I was just going on my own public information. And I just was really, I thought that Mr. Bradel, I said, oh my goodness, get him, Tim. And he did great. Then also, if we could, I will go into any other motions that we were thinking about. But last night, Mr. Bederow, you really kind of knocked our socks off with another installment of a Bederow Letter. And this was quite the
I don't think
Bederow.
last night, but I mean, I think somebody shared it last night. But yeah, anyway, go ahead.
Oh, yeah, pardon me. I saw it, public information last evening.
Mhm.
And it was quite, you know, I mean, when I think that things can't get more convoluted, more, um, entrenched in the web of like all the parts and how the web has been woven, right? Last night was wild, or what I read
So
from the letter was incredible.
I don't think it's convoluted. I think it's actually very
Oh,
straightforward and simple. The problem is that the relationship between the powerful people, whether it be the district attorney's office, the police department, and
yeah,
local politicians and prominent citizens in that town. The problem is it's just incestuous to a degree that can breed corruption, depending on what it is. But in all fairness, it's not complicated. So
oh,
we
okay,
filed, or I wrote a letter asking the Canton chief of police to commence an investigation into illegal wiretapping, and laid out in the letter why we believe that was a concern. And of course, the impetus of it was what happened to an existing client. But the letter also said this is a larger problem here,
right,
and you should look at this. And in the letter, I did say that if for whatever reason you believe you have a conflict, then let me know, and let me know where you're going to send it. And in all fairness, the letter I got back, albeit 10 days later, whatever, the letter that was returned from Chief Rafferty was
yeah,
exactly addressing that. And it said that, the Canton police, there may be an appearance of impropriety because of who Chris Albert is. So I'm going to send it to the Norfolk DA, which is an ironic place to send a potential conflict, but allow them to decide whether they want it or not. Now, the only problem that you could draw from Chief Rafferty's letter is if there is an issue because he's a selectman, which I understand and appreciate, then could he ever be investigated for anything by the Canton police because he's still going to be a selectman? In other words, is everything carte blanche, we can't touch this? I don't know. I don't really care. But the reason the letter was sent to Morrissey, Mr. Morrissey, was to let him know right away, before you even begin to entertain this, unlike the letter we sent to the Canton police chief, which was, if you think there's a conflict, let us know. I get it. The letter to Morrissey was, you 1000% have flagrant and obvious conflicts that are wrapped up in Christmas lights blinking all over the place. And if you were to
right,
look at this and touch this and you don't do anything with it, it'll just make everyone in town think that this is a corrupt operation. So the purpose of the letter yesterday was to make it damn sure to them and outline the actual and obvious conflicts. Number one, they hate the client. In fact, every time that there's been a prosecution against a client, what do? They recuse themselves. There have been a few cases in which that client has been a complaining witness. What have they done? They recuse themselves. That's the first obvious thing.
yeah,
The other problem is Chris Albert is currently a witness in a murder case you might have heard of, and he's all prosecuted by that office.
mm-hmm.
So is son, Colin, who is involved in this incident of March 4th and is another alleged victim of witness intimidation. And they're both witnesses in the Reed case, and they're both witnesses already against Aiden in another case. So do you believe that the Norfolk DA's office has the ability to investigate and potentially discredit their own witnesses in these critical prosecutions? And then you get particularly to the Reed thing, which is they announced in court the other day, Karen's lawyers, that they fully intend once again to name Colin Albert as a potential third-party culprit. Obviously, the DA's office has every reason imaginable from their perspective to oppose that and defend his credibility and his father's credibility, obviously. So,
Right.
does it make sense that they're going to have a conflict or no conflict when they were potentially looking into criminal violations of the wiretapping statute and what could harm one or both of them as witnesses? That alone would be a reason to get a special prosecutor. But I mean, the best example is, the ridiculous video that the DA made in the summer of 2023, which tells you as much as you need to know, which is that was a defense of the Albert family first and foremost. It was also made in opposition to Aiden, clearly. I mean, that's who they're talking about when they're complaining. So, but if you watch that video, there's one individual in that video who is defended and named again and again and again. It's Colin. And the question is why? And, you actually had the district attorney make a statement that, Colin didn't commit a murder, which that's fine that that's his opinion, but that's not the opinion the district attorney is supposed to share by making a public statement and widely disseminating it to anyone who wants it during a pending murder prosecution. That's not what they're supposed to do. And then you find out that someone who may very well be the person who we're asking to be investigated, his wife and mother of Colin, possibly, probably, it's redacted out. That was a email that I think was released as part of a FOIL request a long time ago, a year ago. That was out there publicly. That was just floating around.
Yeah.
The point is, if you read that email carefully between Julie, which we, on information and belief, I think common sense would suggest it's Julie Albert. If you follow the context, on the very day that Morrissey made this ill-advised video, was communicating with his press officer and Chief Rafferty, and through Chief Rafferty to the DA's office, was adding input on what the DA should say in this statement. And you can see it in the email. I mean, this is irrefutable. Whoever Julie was speaking to Rafferty, who was speaking to the DA's office, and then the press officer said, we're in essence literally filming the video now, and we're going to add what you want us to add. Okay. And if that person is Julie Albert, what do you think she would want to add? Protect my son.
Yeah.
Obviously. And then lo and behold, when this video is made, who gets mentioned again and again? Colin.
Yeah.
Not Jennifer McCabe, not Brian Albert, not Brian Higgins, Colin Albert.
Right.
Now, what does this all mean? That's for other people to decide. What it means to me in the context of this is you have a conflict of interest and you need to get a non-conflicted prosecutor to look into whether a certain location in Canton is conducting illegal wiretapping and has been doing so for some period of time. That's all the letter says. You have a conflict and spells out why. Other people can, draw whatever conclusions they want. Our point is we just want a fair investigation that the public will have confidence in. And if the Norfolk DA does it, no one will have confidence in it.
Yeah, I totally agree. And thank you for laying that out, because just how it was, because you're so right. It's so straightforward. It's not convoluted, right? I mean, there are tentacles here, but it's very straightforward. What I still go back to DA Morrissey's video and the unprecedented, aspects of it was that, I mean, if Colin Albert was his client, that would make sense. But DA Morrissey is the DA for all public, right? Karen
Well,
Reed
yeah.
is presumed innocent until, until she has a fair and impartial trial and, whatever. There is this complete lack, in my opinion, of like obligation to the Commonwealth, to duty, to you. Like it felt so out of control in 2023 when he did it. But now looking back at it, Mr. Bederow, it is like it's a 5 alarm fire when I watch that video now. And it's
Well, yeah.
just
Well,
him making argument, giving evidence in his
the,
statement before trial.
the
He provided evidence.
the word you're looking for is unethical.
Unethical.
I mean,
yes.
under the rules of professional conduct, there's no question. I mean, it probably violated a certain rule that lawyers are familiar with probably 10 different times. But the
Yeah.
point is that if there was an issue where, Colin Albert was being unfairly attacked in the eyes of some, he had representation back then. Very good representation. Very good representation. And not a shrinking violet either. Okay. So
Yeah.
my point is, it would have been entirely appropriate for his lawyer
Oh, for
to
Joe,
get
yeah.
up, say, get off this kid's back. He didn't do that, whatever. Okay. The problem is the DA is doing it. And what he's doing is he's vouching for the credibility of a witness in a murder case, which is a no-no. You can't do that. Now, and there are, and he's basically declaring the defendant guilty, and he's vouching for the credibility of all of these witnesses. All of that is bad enough. But what appears to be more concerning, as if it's not concerning enough, based upon the email that we saw, and was included yesterday, is that there appears to be taking input from actual witnesses in disseminating a statement that the district attorney has no business making in the first place. And it's bad enough that he would make it and then send it to the world. And if you see the full body of public emails that were released, they blasted it to every media organization from here to Timbuktu, saying, watch this, watch this. I mean, there's about 50 pages of emails of the press officer forwarding it to anyone who will listen to this. That's bad enough. But when you're huddling with the actual witnesses and advancing their agenda on their behalf, the impression is that the DA is not serving, the Commonwealth. He's serving the Alberts. That's what it looks like. Okay. And whether that's true or not, it's an appearance of something that is highly improper. And when you find out all the other stuff that goes on, it becomes very concerning. I mean, when you see him say, Michael Proctor doesn't know anyone in the family, it's not true. Who told him that? I mean, did that also come from the Alberts? Did that come from who? I mean, look, this is the problem, though. 15 minutes later, when you talk about the town of Canton and the people in power, whether it be in government, politics, law enforcement, or just long-time prominent citizens, it's too incestuous. And you can't have certain people having a bat phone to the police and DA and others not. And at the end of the day, we just want a fair investigation of the issue related to the wiretapping. And you can't have that. You can't have that in a town like this that feels like the movie Copland. You just can't have it.
I know, you're so right. And the only one, I just would like to have a bat phone directly to you. Okay. But we are private citizens. And this is why, I, as much as has been such a roller coaster, so just really taxing, no pun intended, on so many, including the O'Keefe family, including the Reed family, Turtle Boy, anyone else that has been, prosecuted unjustly. And it's just that we're sitting here and looking at it, and it feels to me as though it needed to happen this way, right? Because things would have continued as much as all the sacrifice and everything that has happened at some level, the corruption or the collusion or the, good old boys club, the tall blue wall that was erected, like the shit needs to end. This is not, where we as the Commonwealth are not going to, as residents, will not continue to just sit back and like allow it to keep happening, because it could be any of us in one moment of our lives. Everything could change. And I applaud everyone that continues to go forward and like marching on. This, it feels like it's been a battle, and I have battle fatigue at this point. And but at the end, we will have truth and justice, and that's all we've always been in pursuit of, right?
Yeah, I mean look, if you live there, you want the people who are in power to use it well, wield it well, not be corrupt, be fair, and just treat everyone equally, certainly in law enforcement. And that's it. And whether the problem is, again, due to all these relationships, whether it's fair or unfair, whatever your view of a, certain pending murder case is, or what you think happened or didn't happen, the point is the credibility of the DA's office, the police department, the state police, and their connections to certain people has completely discredited all of them and has really harmed the public's confidence in how the system works, at least in Norfolk County. And that's not good.
Yeah. Nope. Totally agreed. So, yeah, with that being said, was there, if you had to go rank, what was your favorite motion in limine that you heard from the defense side? Let's start and then go to the pits of hell with the Commonwealth.
So it's hard for me, literally off the top of my head, to remember every. No, it's fine. I mean, look, there was a time period where mentally I was prepared to be invested in thinking about this 24 hours a day, whatever. It's not the case. So, although I certainly follow it carefully and whatnot, it doesn't dominate. The one that I find interesting, I guess, that comes to mind, is the concept of having an expert explain how investigations work. That, to me, will be very effective if allowed, because there are certain things that were not done, and they're very basic concepts, but it does require expert testimony, especially when you're using a defense that the police screwed things up and that sort of thing, that you really need somebody to explain to the jury why. And I think most people, when you say like the crappy investigation, they actually focus on the lesser important stuff because it sounds more shocking. And what I mean by that are like solo cups, stop and shop bags, and leaf blowers. I mean, that's all bad. That's really bad. But in terms of crime scene investigation and things, it's the other things that are really important. Somebody needs to explain why it is critical that you secure a crime scene from the beginning until the end. And in this case, the answer is because if they had done that, right, all you need is a police officer literally to sit there in a car. You don't need to have an army of 15 guys. You need eyes. You need someone to make sure nobody goes there.
Agreed.
If they can say that the cops showed up at 6:15, whatever it was, and connect that dot all the way to when the CERT team showed up.
Yep.
Just however many cops, because they switch after 2 hours. If you can establish that perimeter was secure and no one came in, no one came out, nobody went anywhere near the flagpole and the fire hydrant.
Yep.
If you can do that, and they say we found, a few pieces of glass or taillight, whatever it is, then that issue of at least those original pieces being planted is gone. Yeah. It's there. But They didn't do that. And they didn't even try to do it. And they didn't even do it for 5 minutes. That once the Canton police left, they left. So you have no idea. So that's important. The other thing is the importance of preserving evidence as it relates to a murder weapon, which literally speaking in this case, if you believe the DA theory, would be the Lexus.
Mm-hmm.
It's no different than a 9mm used in a shooting. That's the, vessel of.
Yeah.
So an expert, I think, is going to talk about documenting evidence and whatnot, and how the problem is if the lead detective, who unfortunately for them is now terminated, disgraced, and what other words come to mind, says sometime on January 29th that I made a determination because I saw that John O'Keefe had one shoe on and I spoke to Jennifer McCabe that this was definitely a hit and run, which is, I'm paraphrasing, but that's what he said. I don't mean literally, but generally that's what he said. Missing a shoe, and McCabe told me. So he goes down to Dighton, and the other thing that he says, and this is really important, and I think it's one of these points that just kind of glazed by everyone the first time, he ordered a tow truck before he ever got to the house.
Fuck, he did. Pardon me. Yeah.
So that tells you two things. Number one, it tells you he's taken the car, and I'm not getting into the legality of that. I'm just telling you he was taking the car. But number two, it also tells you in his mind, this is a hit and run, and I'm going to build a hit and run case, and I'm a good detective, and he denied having tunnel vision, and I'm going to gather all the evidence because I know she did it. So they get down there. They get down there at about a little after 4 o'clock or whatever it is, and sitting in the driveway of this house is the so-called murder weapon, right? It's the murder weapon sitting there. And over the course of time that he was there for an hour, give or take, whatever it is, neither Proctor nor Buchanan, and by the way, Buchanan is even more senior and more intelligent and presumably less corrupt than Proctor. Neither one of them
took a picture. Yeah.
That's all. Yeah. And that picture would have metadata, another word you like to hear about in this case. And you'd have a picture of January 29th at 4:15, whatever it is, right? You'd have proof of the time of the picture.
Yeah.
And if that taillight is in the same condition as it is on February 1st, when they took a picture 3 days later where it's missing a lot, if they have that picture on January 29th,
have nothing to talk about. Yeah.
Okay? And you have the crime scene secured, what's the defense here?
You know what I also was thinking about too, Mr. Bederow? I watched back, it was pre-trial hearing for, oh no, I lied. It was in 1.0 when Laura McLaughlin had requested for consciousness of guilt for Karen's Google search for a DUI attorney on January 29th, 2022. And then I had missed it, or I didn't register it when it happened. Mr. Yannetti provided a phone call from Trooper Proctor, his personal cell phone, to Karen 8 fucking minutes before she had done that actual Google search and said, hey, like pull up, bitch, I'm coming. And so she was aware of that. The Commonwealth tried to say that there was that's her consciousness of guilt because there was no engagement from Proctor. And I thought to myself, additionally, he's making calls to Karen, who he's already booked the freaking tow truck, and Barros is going. They're meeting them there, and he's already got all this shit in motion.
You would be a fool if you are not calling a lawyer at that point. But this is also the fundamental problem with how that office operates and their culture of prosecution. They are hyper aggressive. They are over aggressive, and they're supposed to wear the white hat. And, you could ask any lawyer, whether they're, YouTube people or lawyers who go to court, and say to them, the idea that a prosecutor wants to introduce evidence of somebody involved in what she would have been involved in at that time, with all these events that had already occurred, as you described, having the temerity to call a lawyer, and a prosecutor is going to argue to a jury that somehow shows consciousness of guilt. They just have no respect for the Constitution and your right to counsel. And that's, if, free legal advice, you should all do that. Okay, if something's going on, whether you're guilty, innocent, but you're aware of something going on, you call a lawyer, and you don't draw a negative inference because somebody seeks legal counsel. And for them to get up with a straight face and say that was consciousness of guilt, I think they said the fact that she went to Dighton in the first place was consciousness of guilt, which was absurd. And again, they don't really think it through. Where'd she put the car in Dighton? Right on the driveway for everyone to see. And she parked the car, ass out, meaning the rear taillight is facing the street. Yep. Not in the garage, not backed in the other way, not, drop the car off at some rest stop somewhere. The idea that seeking shelter at your parents' home after something terrible happened, after you had left the O'Keefe house and, by all accounts, we're getting a feeling of I'm not wanted here, whether people believe that or not, it doesn't matter. But the idea that in that situation, the one place you go is to the comfort of my parents evinces a consciousness of guilt, that's just embarrassing for them to even suggest that. But that's,
yeah.
They are going to grasp at straws. I mean, again, they're going to look for any communication between the two clients that we spoke about and try to argue with a straight face that somehow evinces a consciousness of guilt. That means, I'm worried about getting convicted of murder. So if I'm talking to you about a witness in a case, I should be charged with a crime. I'm guilty of something. Right. I feel guilty. They tried that. They did try to charge her with a crime, and a grand jury said no. And they did it, by the way, and this shouldn't be lost on people either. They did it in March of 2024, right before the trial was going to start. And that would have done two things. Yeah. Number one, would have been a huge, huge story while jury slips were already out, that the alleged murderer on top of that just got indicted for intimidating witnesses. I mean, if I'm the defense, I'd be asking for an adjournment for at least 3 months, even for trial, because of that. But secondarily, what do you think they would have done if she got indicted? Right. They would have tried to lock her up. So she's trying the case, being brought in and brought out every day.
Yeah, my gosh, it is enraging to me at times. What did we think about? I had a couple of specific motions that I thought for the defense were interesting. I knew that Judge Cannoni would definitely deny the speaking objections, but I thought that Mr. Yannetti really put on a great, argument for it, or his oration and oral argument of like, hey, we should be able to give our, foundation. We're not going to do like a speaking or get lost in the sauce with it, but just either saying like foundation relevance, there should be some sort of checks and balances for where she is making those determinations. And she said, no, thank you. What did you think?
Well, I mean, look, every judge runs their courtroom differently and does it their own way. I will never understand a blanket rule that for no apparent reason other than it's the way we do it, is that I don't want to hear reasons. And then if I do want to hear reasons, come up to sidebar and all that. So the first concern is it's a practical one, which is not even the primary one, meaning over the course of a 2-month trial, going to sidebar every time there's an objection probably added 5 hours of actual wasted time.
Yeah.
That if this had been done. So again, I come from a different culture, legally speaking. It's commonplace to object, hearsay, whatever. Some judges will do it differently. They'll say, don't state a reason unless I ask. But you're not going to run to the bench. The judge would just say, what's the nature of your objection? It calls for speculation, hearsay. It's a leading question. No one's offended. Oh my God, the jury is going to be destroyed because they're hearing about it. So it makes no sense to me. And then for legal reasons, you have to allow them to make a record because they have to preserve the record for appeal. And if there's ever an objection that somehow becomes relevant, if there's an appellate issue, and of course, if there's an appellate issue for Karen, that's bad because that means she came second. But whatever, lawyers always, try to preserve the record. You have to do that. And all the judge is doing is encouraging the defense to seek a sidebar, 50 times an hour. And one of the other problem is this. And, I saw this when I started looking at a couple of weeks ago, some of the prior proceedings in the case, just looking at them. And it occurred to me, particularly from a cross-examination standpoint, how disjointed and broken up and choppy the trial was. There's just no flow. There's no cadence because there were so many constant interruptions, sidebars, and there are very few clean pages, if you will, of a transcript where there aren't interventions by, QA. There's just so much other stuff going on, and it really just takes away from the flow and cadence. And I think it's unfortunate, but that's how she does it. That's how she's always done it. So that's how she's going to do it, but that's her right. I don't agree with it, but what are you going to do?
Absolutely. And I took particular offense with the kind of the motion for jurors from the Commonwealth now that for the public not to be able to use descriptors of jurors. And during trial 1.0, clearly media or public have no idea a name of a juror or whatever. But Jess Machado, I used to be I love her reporting. I think she's an incredible independent journalist. And she made me feel like when she would report a vibe, right? Do you know what I'm saying? And I thought, and she did such an incredible job for us who were not there to get a sense, right? Because that's all you're wanting. It's not to be, it's never to be nosy or trying to invade the privacy of jurors. It's what was the reaction? Give me all the shit. Tell me everything, and for Hank Brennan to say that no one has that right, is that not a gag order or a prior restraint on, you know what I mean? Wouldn't that, I feel like that is ballsy and that should not be allowed.
I feel like it's just par for the course in this case in the past several months. I mean, it's just nitpicking, needling, and anything you can do to reduce coverage. There ought to be more coverage, not less. Certainly, First Amendment it's a high-profile trial. There are serious, just on top of the public interest because it's an interesting case, but more so because there are very serious allegations of professional misconduct and corruption. You've seen one trooper have his life and career destroyed because of his corruption and conduct, or alleged, and certainly his misconduct in the case. So there ought to be more light on this case, not less. Obviously, there have to be some limits. I mean, you can't have or should not have a juror being concerned that I'm going to be identified by their name as, being on the jury. But the idea that we're literally now talking about juror 1 through 12 who are just 12 widgets, I think this is ridiculous. It should not be offensive. I don't think there's any legitimate reason not to say that juror 1 is a white male in his 50s Juror 2 is a Hispanic female in her 40s or whatever. You know, Juror 3 dresses up in a suit. Juror 4, you know, shows up in shorts and a tee. I mean, but this is part of the problem, okay? They come in here as the prosecutor and they're used to the power and the government and they think they control everything and they just want to control every little thing. They want to control the release of information. They want to control who's allowed in the courtroom, including keeping reporters out. They want to keep, you know, people from protesting too close to the courtroom. We want to make sure they, you know, can't wear anything. And within reason, I understand that. You should be wearing a shirt that says, you know, Karen is innocent in a courtroom. That's not appropriate. But all these little things that the DA just feels we have to control. And that's part of the problem with everything they do. And part of the whole problem that people have with the way that they conduct themselves there.
You know, and isn't that telling also, Mr. Bederow, that like we're looking at this and it's the control about the perception, the media, the whatever, us, you know, me online talking about it. And I feel like there's much less of that focus and that micromanagement or that attention to detail, if you will, regarding evidence, regarding actual, like the actual death of Officer John O'Keefe. Shame on the Commonwealth, in my opinion. Okay, because you put a lot of emphasis on shit that, you know, is not your place, and you're not caring about what should be.
There's a lot of things that they're doing that certainly in my view and many others' view is not their place. I mean, look, they have every right, if they believe that someone's committed a serious crime, they have an indictment, they want to try someone, they have every right to do that. We can agree or disagree, but they have to do it in a fair way and certainly with respect to the constitutional right to a fair trial. And you know, this is another really annoying point. You hear them always talking about, you know, our right to a fair trial. Now, in principle, you can say that the district attorney deserves fairness. They do. They deserve a judge that's not going to be biased against them. They're entitled to a fair trial in that regard. But when he tries to equate the DA's right to a fair trial with Karen's constitutional right to a fair trial, those two things are not even close to the same plane, okay? The purpose of a constitutional right to a fair trial and the Bill of Rights and all of that is to make sure that the defendant is tried fairly in a way to make sure that there isn't a miscarriage of justice. And the law favors, if there's a mistake in the outcome about literal guilt or not, that it err on the side of the defendant. And you don't want them to be wrongfully convicted rather than perhaps wrongfully acquitted, if that makes sense. So when you see them talking about their right to a fair trial and in the process of introducing their own evidence, moving to exclude every possible defense, every possible witness that the defense has an absolute right to put forth, you know, on behalf of Karen's defense, and they just want to keep it out and keep it out, that's not their job. And this is strange. I mean, to see them trying to, you know, disqualify every expert, to see them, you know, that we shouldn't allow the most exculpatory witnesses that could ever exist, the ARCA guys, because there's allegedly a ticky-tack, frankly, irrelevant, non-material disclosure obligation, which we can talk about in a minute. When you see all of that, you say, what are they really trying to do here? I mean, what they're suggesting is, why don't we just skip straight to sentencing? You know, right. That's what it feels like. So it's very unique in the way they're doing it. It's a terrible look. And, you know, I say this to people all the time. If this is the first trial you've ever watched, this is not a good test case, because this is not normally how these kinds of things work. And, you know, the bow tie on that was yesterday, when, you know, we've reached a point where now I need to look at every communication for 3 days between lawyer and client. I mean, this is just stuff you never see. even if there is a ticky-tack waiver.
Yeah. Yeah, it's like well, would you agree or not agree? How do you feel that I never thought I would miss Adam Lally, right? And I'm not saying that I miss him because I can't what if anything myself again. And I know it's just, it feels like you're watching two defense attorneys, go at each other versus the prosecution. Like there's no steady hand. There's misrepresentations to the court from the Commonwealth that has not been addressed at all. And I mean, these are material misrepresentations, in my opinion, when they were talking about, getting all this information from a TUI request when really it came from who? Liza Little in a friggin' email and reciprocal discovery.
What's interesting about that is, so you had this defense team taken to the carpet completely unfairly, in my view, about and get lectured about, if one of you knows something, you all know something.
Yes.
Okay? Now, and they had to stand up and be humiliated. I mean, these are expert professionals at a top level of practice to be treated like that. But to your point, with the example you just cited, and there are many others, Lally's sitting right there. He knows everything. He knows the procedural history of this case more than anyone else in the courtroom because he's been involved with it longer than literally anyone. So when Brennan is making those statements, where was Lally to stand up or McLaughlin to stand up and say, you're wrong? That's apparently not a problem. Anytime he's made other misstatements about the state of the evidence or what happened during the first trial, or, it doesn't seem, at least visually, the same principle to apply. And that's concerning. But in terms of he's there, so I assume he's going to do something at the trial. I don't know to this day why Brennan is there, and not that he's not allowed to be there, but the thing that I find so confounding and always have is that the fact that these same two prosecutors from the first trial are there is indicative of Morrissey's belief that I don't have a conflict because they wouldn't be there if I did. But nevertheless, I had to bring in a ringer, a defense attorney, to try the case in the manner that he's trying it, at this level of aggression, which again is unheard of for a prosecutor, unheard of.
Yeah.
To be this. And the question is why?
Yeah.
Why am I paying the salaries of my two regular employees, and the taxpayers are going to be out, by the time it's all said and done, $500,000 or whatever it is to pay for this as well when I have an office full of 50 or 60 people? It doesn't make any sense unless you say, did nobody want this? Is nobody capable? And that starts to get into the motive for continuing prosecution. And is it personal? I don't know. But, you have to be guided by evidence and clean thought. And if there is another agenda here, that would be very troubling.
Yeah, I totally agree. And could I ask you, Mr. Bederow, is it as the public, right? Now, this is a little off base, so try to follow my ADHD logic here. We know that in 2024, Mr. Lally got paid $149,000. Law McGlaw got paid $119,000. We know that Hank was retained and his initial contract was for $75,000. It has upped to $225K. We had over $500,000 paid for trial number 1 based on the breakdown by Ted Daniel and, Mass State Police, overtime, a whole shit show of monies coming. And I'm just wondering, is there any transparency, or how are we as the people, are we able to find out why was Hank Brennan chosen? How the frick did this come about?
It's very simple. A reporter sticks a microphone in Michael Morrissey's face and says, why is he here? And again, that's not a disparity. He has every right to be there. He didn't do anything wrong by agreeing
No.
I mean, there are some things that we can be critical of him, but his presence is not offensive. I mean, I don't know why he would choose to do this, but I don't really care either. But anybody, any reporter at any time could stick a microphone and simply say, if you have no conflict of interest and you run a DA's office that has 50 or 60 attorneys, you have homicide prosecutors, why do we need as taxpayers to pay more?
Right.
I mean, that to me is the most obvious question that's never been asked. So, I mean, yeah, the remedy is people could ask him all the time, and
I'll call him.
he may not answer it. I mean, I don't know what but I mean, it's a fair question. And again, the key part of this is by having his two original DAs there, he's telling you, I have no conflict. So if he has no conflict and he has competent lawyers, it can only lead to two possibilities. Number one, no one in there will touch it with a 100-foot pole. Or two, he doesn't think anyone in his own office is capable, and that's another problem. So he went to choice three, which is I'll just use more taxpayer money and bring in a ringer.
Agreed. I just was wondering, like,
why? I mean, it's totally a fair question.
Yeah, I was just like, I was thinking to myself, I was like, I just don't and I didn't know if I had a right to know it, but I was just like thinking, why have we not said or been given like this is, or when they announced his hiring, right? It didn't say anything of like, oh, and we hired him because of this was the process we went through. He can be there 100%. No one is arguing that Hank Brennan should not be there. I just want to know what was up with the other 61 of our in-house options, right?
They were all focused on, he was the second seat on Whitey Bulger. Now, from a lawyer's perspective, big cases are great. And of course, Whitey Bulger in Boston is like, peanut butter and jelly. I mean, so I get that would be part of, they got a real prominent lawyer to try the case. But that's where they just stopped. They never asked the real question, which is why. They got too wrapped up in, Whitey Bulger. And, but there's another thing about
the feds component though. Yeah.
Well, but here's the thing. Exactly. But here's Whitey Bulger as a trial. Zero pressure, zero. That is a trial as a defense attorney that you play with 100% house money. That's for shits and giggles and fun, okay? Because they know they're not winning that trial. They know they're not expected to win that trial. They know that they're supposed to go in there, crack skulls, and attempt to expose corruption, have a good time, do the best you can, and then he's going to be found guilty, and he's going to be sentenced to the functional equivalent of life in prison. The point is, that's fun, and that can be very interesting work, and you can get a lot of great experience. That's not pressure. Okay, pressure is when you say, oh shit, I need to win because I have an innocent client in my mind that if I don't do this right is going to be on my conscience because they're going to get sent away. I'm just saying the whole Whitey thing is interesting because of who Whitey Bulger is. The trial itself, it's not that interesting.
Yeah. Okay. Agreed. I'm going to just go through a couple. This has been fast and it's already been an hour. And I know that you were out last night with your dancing shoes on for that beautiful little girl who wore the fanciest dress and the best pair of kicks or Jordans that I had ever seen. I hope you guys had a wonderful night together. You're a good dad.
Thank you.
So everyone has the questions. You are calming the nerves of the United States of America today, Mr. Bederow, and we appreciate you. Tomorrow night, Mr. Bederow at 6:00 will be on with one of our favorites. Who is he? Mr. Mike Crawford from the Young Jerks. So full Mel Tash Value said, question Mark's opinion on the defense team on the CW's witness list. What effect will it have on the trial?
Well, again, you can't be an advocate and a witness on a material issue of fact in the case. So if he's serious about it, he ought to explain what it is, and the judge is going to have to figure this out, because you can't have this come up in the middle of trial. There'll be a mistrial. One of her lawyers gets called in the middle of trial, by the prosecution. You're going to have an application for a mistrial, and you're going to have a mess. Look, I think at this point, why David was on the witness list. We kind of, a day later made that clear. Are they on the witness list because of all these interviews that Karen did to somehow authenticate? That could be stipulated too, that's accurate. So to me, it's another one of these stunts, and it looks, it's a way to make a statement without saying anything, because that gets filed. Everyone's going to see that and say, what's going on here? I don't put much stock in it, other than as it relates to this issue that they're attempting to, get to David's communications.
Yeah. And Claire Terry, thank you so much, says, love you, Nurse Kim and Mr. Bederow. Hank is playing this like a defense lawyer, not a prosecutor. We've said that, win at all costs, and not truth and justice, which is the oath of a prosecutor. Like you said, it's unfreaking heard of, right?
I agree with that comment 100%.
Absolutely. We talked about this, and thank you so much, Kate. I loved that question about Mr. Yannetti. And now possibly a Marty Weinberg workaround if needed. Thomas, Autonomous Anonymous, says, thank you so much. Levy said the CW went from trying a murder case with hard evidence to circumstantial evidence to anecdotal evidence. Yeah, I just wish they would maybe, focus more on the evidence. That would be a freaking improvement, in my opinion.
Look, again, you're 10 days before trial, and the issues that they're making hay out of and making a mess are whether they can call, another client or introduce evidence to show this convoluted theory of consciousness of guilt, or whether we can look at attorney-client communications, which presumably wouldn't show a hell of a lot anyway, if they even showed anything. That's bizarre to me, that's the point of emphasis, a week before trial. But
agreed. Who are we? Maddie Wags said, thank you so much, Levy said, dumb question. Someone said Hank's contract ends with the CW in July. He would still have to finish this case if his contract ran out, right? And then they thought maybe that's a reason she's pushing for the 4-1 to begin.
No, I don't think she's doing it to get Brennan's contract honored. And if the case went past his contract, again, put aside what you think of him. If he does the work, he's going to get paid, whatever. I don't put any stock in whatever. Look, as far as I'm concerned, whatever they're willing to pay him, good for him. That's not the issue. The issue is, why are we doing this as taxpayers when you have an office? But I don't fault Brennan for getting paid as much as he can to do high-level legal work. I don't like a lot of the stuff that he's doing on the case, and in the last few weeks in particularly, including as it relates to me personally, when he makes very false and inaccurate statements with no basis in fact to do so. But putting that all aside, lawyers get what they can get. And if Morrissey is willing to bill the taxpayers and get approval to do it, people aren't asking the right questions.
Agreed. And Amy's Positive Pathways, thank you, darling, says, if the CW gets this waiver, do lawyers actually text these things? It would be a call or in person, right? My ex might have been a criminal, never left a text or voicemail. He used to make threats. He was careful. Listen, I'm so sorry.
Listen, I'm not going to tell you in a literal sense, if you put yourself in these people's position on January 29th of 2022, where a lawyer gets a call on behalf of a woman who is accused of running over a police officer on another police officer's lawn, right away, this is going to be a crazy case, okay? Mm-hmm. Putting all that aside, no lawyer is ever thinking in that moment that 3 years from now, some prosecutor is going to demand to see this. Now,
right.
It's a fair question to question why Karen was in position to appear on TV and talk about those communications.
With counsel next to her, yeah.
That's a different question and not one that I can answer. But no way in real time on January 29th, 2022, that they would not communicate in some written format because, Big Brother 3 years later is going to demand to see it.
Yeah, absolutely.
If you're not a lawyer, yeah, but lawyer and client, no, you're not thinking like that.
Ashley Linnell, thank you so much. Levy says, why is Hank asking for Arca's communications, emails, and calendar? He said he would as after voir dire based on what they say. He said he would.
This is there are a couple of reasons. Number one, you can tell these are the witnesses that he fears. Okay.
Yeah.
These are the witnesses who end the case if they're credible. And notwithstanding, he keeps suggesting they change their opinion, or the bottom line is if these guys testify credibly in the eyes of the jury and say that based on physics, kinetics, engineering, and all the other sciences, none of which I understand, but we accept what they're telling us, that they don't believe that the injuries are consistent with the DA's explanation, and we don't think the car damage is consistent with the information. That is by definition reasonable doubt. Like, forget it if they're credible. So, but that's not why he's doing this, really. He's doing this because he hates Alan Jackson, okay? Because he smells blood in the water, because he's got the judge willing to follow him down this rabbit hole of what I'll call a nothing burger over what's going on with Arca. Just from watching these hearings in the past few weeks, the bottom line is this. Start with like the payment, for example. You can't disclose evidence that doesn't exist. So if the Arca people say, hey, we have a small expense for 20 plus grand a month after the trial, there's nothing to tell the other side because it doesn't exist, unless there is an agreement or an understanding that would have to be disclosed, a promise, right, an expectation, because in theory that could go to bias, in theory, but there's no evidence of that. And I'm telling you right now, Brendan's not even going to ask these guys at trial about the $20,000. And if he does, he's a fool, because the opinion came first.
Yep. Okay.
By the Justice Department. They're hired by the Justice Department.
DOJ, yep.
The opinion comes next. They're introduced to the defense because they contact them, because obviously when they get the report, they want them to testify. The DA doesn't. I can't imagine why, right? That obviously. So look at those guys. They're about, compare them, to Trooper Paul, for example. It's like night and day. Are you seriously cross-examining these experts who got paid, I'm going to guess, in the area of $500 to $1 million by the federal government, all inclusive, I would imagine, that their testimony is somehow biased, or there's a motive to favor Karen because they sent her lawyers after the trial, apparently with the blessing of the federal government, I think they said, I don't even remember, a $20,000 invoice, and the defense, as any defense lawyer would in that situation, arrange for payment. Now, it doesn't get disclosed, apparently, and there's a mistaken statement made about that, but that says ticky-tack, nothing, nonsense. Moreover, it has been disclosed. They are aware. It was
disclosed by, in reciprocal. I don't even understand, though. There was nothing to present to the defense during the trial. Unless you want to say that that Dr. Wolf and Dr. Rentschler prepped themselves because they're professionals.
So they're asking for these communications and emails for two reasons. Number one, because they're desperate and they're looking for the Hail Mary, where they're going to find the email where, the ARCA guy says to Alan, God, let's change it to this and it will sound better. and therefore, like, you know, we'll fool them and, you know, she'll be found not guilty. I mean, none of this is going to exist, obviously, I would imagine. But he wants to argue ridiculously that these are biased witnesses. So that's his first.
Insane.
So that's his first point. The problem he's going to have with that is the opinion came first at a time where they had no reason to favor. They didn't even know who Karen Reed was. They didn't know who the defense lawyers were. They didn't know anything. So they can argue all they want, but the bias argument is not going to work. And the second reason is because he's looking for, you know, inconsistencies in what was represented in court, so he can go back to attacking the defense ethics. Because, as you know, the judge said last week, which I couldn't agree with in stronger terms, and this is one of the most, I mean, from my perspective, ridiculous things I've heard a judge say, that, you know, I find that there was this intentional suppression of evidence. And then not only that, but that I find that you then intentionally lied about it.
Your candor, yeah.
And I'm going to tell you something. If a judge truly believes that, I mean, really sincerely, and has evidence to support that, then you should kick him off the case immediately. If she didn't. Because
what was your thoughts on that, Mark? We really didn't touch on that because that was huge. I mean, that scolding, right, that came from Judge Cannoni, then the cameras panned over to Karen and to AJ, and I lost my shit. I clutched my pearls. And then afterwards, I thought, is she trolling us? Like, is Bev actually trolling us? Because you just talked all that shit. And then you said, just kidding. All right. I just wanted to say that in open court.
I'm not going to use the words trolling or anything like that. What I'm going to say is she made a factual finding on the record, knowing it would be displayed for the world, and said that I've reviewed everything, and she made two key conclusions. Well, three, actually. Number one, you violated Rule 14, which, by the way, I would say if that's even remotely technical, that's as ticky-tack as it gets. That is a, you know, as opposed to, I don't know, not turning over Sallyport video until during and after trial, which I would call a major, but, you know, that's being ignored. That's number one. The second thing she found was that you did it on purpose. It was intentional. Your intent was to conceal the other side from getting this. Yeah. And then on top of that, she said that you weren't honest about it. You lied about it. And then, but she never gave any factual support for that, which is really troubling. But the point is, if you believe that, and there's a very important murder case going on here, and you've just taken these lawyers from the carpet and said, you're full of shit, you lie about it, I can't believe a word of what you say, and you're not even admitted in this state. If she truly believes that, and there was a factual record of it, there was only one thing for her to do.
Yeah.
And the other thing which is interesting is this. I know they like sidebars in that courtroom. And before you throw out what she threw out publicly, it might have been time to call them up and say, listen, you got anything else to tell me? Because I got something to say. And I want to give you every opportunity to convince me that I'm wrong or overreacting, because this, you need to know I'm going to do this. She didn't do that.
That does say a lot, doesn't it? You know, it screams, you know, that it was happening no matter what, and it was happening in open court, and she was still pissed about it so many weeks later. I'm like, I thought that once she went back and reviewed everything in camera, that she would have been able to like see, like, that it wasn't how it was presented. And I mean, for her to take even that unprecedented step of only hearing an oral argument from Special Prosecutor Brennan and literally halting.
Well,
the entire procedure, but she didn't even see anything, Miss Bederow.
I'll give you the same example. That was a time, I'm going back several weeks now, when the grave concern is, that was a time when she comes back to say, step up. And what I would expect the judge to do in that situation is to look at the defense and say, oh, I'm worried. I got issues here, and you need to know I'm looking at you like I think something bad happened here, and I'm going to give you an opportunity. You want to be heard now, or do you want the break?
Right.
Let me know. And then they could have decided how they wanted to do it. And if she was going to adjourn it, she could have held her comments and just adjourned it, not create a media prejudicial story. But instead, when she came back out, she just kind of lit into them and then said, I don't want to hear it. The big press story comes out, but lost in the shuffle of that day is Brennan, when he said, I got this from the feds. And again, remember candor to the court and how important. It's not just that he got that wrong. He wound that up for 15 or 20 minutes with vignettes and stories and threads that, that was planned. That wasn't seat of the pants thing. And as he was saying that, nobody corrected him. Nobody from the prosecution table said, time out, like, you're wrong. But a funny thing happened after he made the speech, when the judge came back and was clearly upset. He did. He knew, I need to fix this.
Screwed the pooch on that one, yeah.
Well, screwed the pooch, but there was no concern about his lack of candor or making a blatantly, materially false and extremely prejudicial statement as it could impact the defense. Yeah. And that's happened again and again, where there have been statements he's made, which are not, and again, I could count how many he said about me. Absolutely, positively false, and good for him that he did it in open court because he gets the litigation privilege. If that was said outside of court, I would have had a real problem with it. Okay?
Yeah.
You can do that. They don't file, sworn statements. They just kind of, they hit and move on, and they throw, they make a lot of non-objection objections, and she allows it, but they don't get criticized the same way. And it is true from people who observe everything that's going on, it does appear to get harder and harder to look at this and say, this is starting to feel to some extent disparate in treatment. And I mean, you see it many ways. I mean, there was comments made the other day when Bob was going to speak, before he could get a word out about, don't do where you're gonna, you're gonna
tell me what you're gonna tell me, and then tell me
that there is. Let me tell you something. That guy is a professional. Okay, that guy is a high level, brilliant lawyer. Okay, who does high level work in courts, in New York federal court and other things that are very belt and suspenders. Okay. He doesn't need to hear that. There's just, in my view, I don't know what the point of that is.
Can I tell you that it was akin to how I described it? Is Mr. Alessi is like our teacher, right? And I feel like not only are his actual filings incredible, that Judge Canoni has said to him, hey, you don't need to argue as much as you do because you've included it all in your filing. And it's like, hey, I feel when I watch him, and I know that some people might think that, like, oh, get to the point or whatever. It felt to me like the first time I saw you on with the young jerks. You know how I always tell you that you're like a professor and that, like, you teach us and you break things like down for us? The way that Mr. Alessi is able to get up in open court and not only hit all of his points methodically, laser precision, he also is is just incredible in the overall presentation, in my opinion. He gives you from A to Z, and that is how you are going to have the best chance, in my opinion, of getting it approved. I'm like, is he our Bederow? Is he our Bederow right now? But we didn't, because we didn't have you. But he is so good.
The point is, every lawyer has their own style and how they do things. And if it is offensive, and it's not offensive, it might be longer than other people, but whatever. But he's very effective and really. But the point is, this is another example. If this is really bothersome, call him up.
Yeah,
he deserves more respect than being tongue lashed about winding up to get to the point.
Can I ask you, what was your thought, Mr. Bederow, on the 2-minute rule, right? Because I thought that lawyers were able to have as much time as they needed for the record, to preserve the record, to argue. Like I've seen Judge Canoni in previous hearings say, how long will this take you? I'm not rushing you. And then last Thursday, we get hit with the, like a kindergarten teacher. You have 2 minutes. You have 2 minutes. I said, I felt like that was kind of out of bounds, or that doesn't, I don't know. It didn't make a lot of sense to me.
I mean, again, a judge has the power to control their own courtroom however they see fit. There's a lot of motions, don't want to come back. As long as she does it fairly in terms of time limits and whatever to both sides, I mean, they have the right to do it. In a case like this, where the issues are really important and everything is so high stakes, I'd like to see the lawyers be allowed to, within limits. I mean, obviously, if somebody's meandering on for 20 minutes on what should take 5 minutes, I can understand a judge saying, all right, enough. I mean, that happens all the time in the real world. A judge, if you're just winding and winding, they'll tell you enough. But I mean, the case is as big as it gets. The stakes are as high as it gets. It's pretty complicated as far as murder cases goes. There are emotions flying around all over the place. Most of these issues are very important. I'd like to think that whatever they need to say, they'd be entitled to say it for both sides.
I actually really like this question too, Kathleen, because I know that for Whitey Bulge's trial, which is not anything, I'm just saying I didn't know how long you could have, or if it was just a discretionary by the judge. But in Whitey's trial, which was less than I think actually Karen's was for length of time, or right around the same, they had 3 hours for closing, and we only had 1 in a 9 or 10-week trial. What do you think?
I mean, the judge, again, can make the rules of her own courtroom. Again, if it's for both sides. And if you remember at the first trial, she basically told Lally, you're done, sit down. And I mean, what a humiliating way, to be honest, to finish, literally. Yeah. You're ready to make your, final statement, and you're begging for, I have one more sentence. I mean, so no, I don't like that. I don't like time limits generally. The lawyers who would be giving the summations in this case, I think, are certainly more than equipped to do it in the way they see fit. And look, when they had the Trump case in Manhattan last year, the summations were 4 or 5 hours. Now that's long.
Yeah.
And that requires breaks. I'm not saying that's how you should go, but a case like this, a trial that long where you're not having read back. Yeah. I'd like to think that you do what you need to do. Now, you ought to be able to generally make points in an hour and trim through the fat, but there are a lot of various threads and rabbit holes and things in this case that I think it would be best suited to giving them more time if they need it. And that doesn't mean they would even use it.
Right.
I mean, whatever you can do and say effectively in the shortest amount of time is the goal of the exercise.
Yeah. Mark, will the defense file motion for eliminate and for readback?
I don't know. Didn't they ask earlier for an actual court reporter with a stenographer rather than just, speaking into the machine? Didn't they ask for that previously?
Yeah, we got it though this time.
She agreed. And then that means there ought to be transcripts. Somebody's typing. If that's the case, I'm not a Massachusetts procedure expert, but anywhere else where they do trials, readback is more than appropriate. I'm hesitant to say anything's appropriate in Massachusetts because you find that they do things very uniquely.
Yes, yes, very Pilgrim-esque. Okay, let me just goobity beep bops. Okay, Cornell in South Africa, thank you so much. Levy said, this trial seems to be barreling forward treacherously. Bev and Wet Hanky in charge. Can defense stop by a legal process and get SJC to intervene? No.
No.
Yep.
No. Onward, upward, and it is what it is.
Right. Thank you, though. And then Pro Gamer, thank you so much, Levy, says, I can't believe the feds have stopped investigating. So they indicted Farwell for Birchmore and provided the evidence that KR is not guilty just to watch the Commonwealth continue. Surely they're still on it, watching how far the corrupt will go. Question Rico, love you too. We don't speculate on anything regarding, because we don't know.
Touching the federal stuff at all.
Yeah. And Sassy Vice 420 says, Nurse Kim or Mark, even if they take Davy's phone.
David, I think they need David.
Whose?
David.
Oh, okay. David's phone. Perhaps maybe it's not a big deal. We all know Karen's confusion that morning. If explain, the jury would understand. Yes. They're going to be able to use the statements that Karen has said, right?
Let's assume hypothetically that there is literally nothing.
There's nothing there.
But you are talking about taking an attorney's phone to search communications for conversations with a client. On principle, as the lawyer, I am saying I will fight you every way. This is like a much larger point. Never. This is like similar to almost like, during Deflategate when Brady was, you're not taking my phone. And that's not even a lawyer. That's just privacy and whatever. But if they came at me in a case to search my phone, to look at any communications that are attorney-client, and even if they think that there's a waiver, I will fight them to the end of the earth to say no on principle. And you need to do that. You need to stand up for, the concept of privilege. Nothing is more important in representing a client than confidentiality and the idea that you can speak to your lawyer without concerns that anyone else will know. And so you fight that no matter what, and you delay, you do whatever it is, no way. And again, sometimes these issues become bigger than one case. How does this affect people when this case is over? The stuff that the DA is doing here, it's not a great look. And the guy who's doing it is not an ADA. He's got to go back to the real world when this is over, presumably.
Yeah. Setting it up. Grateful Mom, thank you so much, says Paul O'Keefe had an online affair, sent screen signs on her camera from court. She ended it. Okay, sorry about that. Thank you, though, Levy, for that. In Limine Pickets, I like that. That's an incredible name. Can you speak on what technically happens when a person is named as a third-party culprit? Does that force anyone to investigate the named?
No, they're not going to. But the whole third-party culprit thing to me is a red herring. Obviously, the defense is reasonable doubt. Okay, and part of that is, poor police investigation. But long story short, the reasonable doubt here is I didn't hit him. Okay, the car I drove did not back into John O'Keefe, and it certainly didn't kill him.
Fatal injuries. Yep.
Okay. By definition, if she didn't do it,
someone else did. Yeah.
And you start getting into, there's this, suspicious behavior after the fact with butt dials and Google searches and tell him he didn't go in the house and all of that kind of stuff. Mm-hmm. So honestly, the whole idea that say it was this guy or that guy, that doesn't mean a hell of a lot to me.
Yeah. I have questions on that, but I won't bore you because we don't know the answer, because she went to sidebar with David Yannetti and he said that Well, Judge Cannoni did say, I will let it in. It just can't be during opening, which was the exact ruling from 1.02.
Yeah, and then at the first trial, the first words out of their mouth were she was framed.
Karen Reed was framed. Yeah.
Which means I didn't do it. So to me, this is all semantics. It's not going to impact the defense one iota.
Got it. Thank you so much. Levy says, is it the responsibility of the AG to look into the misconduct of the Norfolk DA's office? Would that be handled by Andrea Campbell? Or
I mean, presumably it could, but let's be honest. At some level, the feds looked into something, and without, again, getting into what they concluded, whatever they're doing or not doing, once they do it, the idea that the attorney general will step in, no. I mean, I just don't see it. The feds obviously dug into this.
Just south of history. Thank you so much, Levy says, Mr. Bederow, if they won't let the defense call the expert, Mr. Easter, I love this. Can the defense call another current MSP or retired, in my friggin' opinion, about procedure and like protocols, perhaps Colonel Noble?
Well,
I don't think he'd go, but
on an expert, you need an expert. You still have to get them qualified and that. But one thing you wouldn't do is you're not going to be so reckless as to you as the defense call state police. What you're going to do through very effective cross-examination is twist the police officers who testify for the DA into knots, and they are going to have to agree there should be a crime scene secured. They're going to have to agree that if you secure a crime scene and nobody gets in there, that means the scene is, preserved for if they find something. There can't possibly be, and even with these people testifying for the DA, a single one of them who will say that not taking a photograph or a video was smart. I mean, there's no good answers for this. So no, if she doesn't allow the FBI agent, I mean, I wouldn't call someone a current sitting state police trooper. What I would do is cross-examine the yahoos that they're going to call.
Okay. Noted, because I thought that would be awesome. Like in my brain, I was like, if she denies, because he's a FBI, right? And says like, this is an apples to apples. I was like, wouldn't that be some shit if a Mass State trooper was like, F it, free Karen Reed. Like, not like free Karen Reed, but like, I'm not going to stand by and say that this is my work or that this is our brethren's work. And if frickin' Trooper Paul is considered an expert, I think that any sitting Mass State Police should be, in my opinion.
I do agree with you that in a perfect world, the ideal defense expert in a case like this be a retired either Mass State Police, local Mass Police, or even an out-of-state cop who can say that I have responded to many, many, many homicide scenes. That would be the gold standard. I don't know why this, that, whatever, but anyone with proper law enforcement experience can certainly, again, assuming they have the right credentials, talk about preserving crime scenes, doing things that you would expect trained investigators to do.
Noted. Okay. And Lori Life 360 for the win. Thank you so much. Levy says, I sure love the Perry Mason moment Friday morning. Can Attorney Bederow comment?
What Perry Mason moment? Just want to be.
I don't know.
Oh.
Laurie, if you're still here, Levy, I apologize.
Clarify.
Can you clarify your question? And I'm sure Mr. Bederow will answer. Amber C says, I recall Bev ruling against third-party culprit defense going into trial 1. Is a ruling needed to allow Bowden? If so, did she allow it? She just allowed it to know. Yeah, go ahead.
It would be reversible error if she denied them based on the evidence. And Michael Proctor is a terminated, disgraced state trooper who was the lead investigator, who one of the specifications of his termination was potentially demonstrated bias against the defendant in the investigation. Okay.
Of this case.
They are being allowed to argue that a dreadful and unprofessional investigation, whether it be incompetence or worse, they're going to argue that. And ultimately, I would think that's what's going to get them the result they need. But they can absolutely are going to be allowed to argue that.
I turned over a lot less. We were duped. $4.99. That actually is a Brennan statement. I know that. Why isn't David the gentleman that responded to Julie Albert on the witness list for the defense?
I mean, it's not a question for me, obviously, at this point. Would that be relevant at a trial against her? That's for others. I mean, I never thought of it in that context. That email was relevant in a letter demonstrating a conflict of interest for the DA because, again, assuming it is Julie Albert, which I imagine it is,
yep.
If she's helping the DA craft a statement to defend her son, who is a key witness in the investigation that we're seeking from law enforcement, then, you don't have to be that bright to see the conflicts of interest in that investigation that we're talking about.
Yeah. Is there a chance at all? I think Martha Chapman, thank you so much for the super chat, Levy, says, is there a chance they flip the seating in court so Karen has her father beside her and Paul behind her? Solves Karen looking back dramatically at her father and creepy staring from Paul.
I would actually give serious thought in the first trial when they switched courtrooms. I supported that because you have to have jurors see witnesses, and the fact that this otherwise beautiful courtroom and historic courtroom is set up in a way where certain members of the jury can't even see the witness's face.
Yeah,
problematic. But given what happened in the first case, where you do have family members sitting on top of the defense, given that you had in the summation, you had witnesses there doing, the Godfather 2, Frank Pentangeli stare at right across from the jury.
Yeah.
I would at least, again, it doesn't matter what I think, but, and you're so hesitant because you've got to figure out how the juror is going to properly see.
Right.
But I would give real thought to that setup that they're in now, where the jury is looking. I don't like that. They ought to be behind, equidistant.
Yeah.
Yeah.
Agreed.
And if you've been in that courtroom and actually in the well of the courtroom,
yeah,
you think it looks small on TV. In real life, the idea that a case of this magnitude and with all this going on and all the ego, which is, you can imagine a courtroom like that, is being tried in this closet courtroom. It's crazy. It's almost insane.
So claustrophobic. Yeah. And I mean, like, you're literally, I was looking at Ted Daniel. I'm looking over, I felt like I could, what are we, less than 10, 12 feet from the O'Keefe's? Like, it was just like, so it felt surreal almost. And then I saw there was no jurors. Clearly I was there in the beginning of March. And, but who was sitting there? Joe Krowski Sr. And he was writing in his little handy dandy notebook every time that Hank Brennan got up to argue something, which when he makes funky faces when he walks back from, which is not caught on court TV or on NBC News 10. And his paralegal was sitting on the other side. But like, I thought it was so weird physically seeing Krowski sitting in a juror's seat. I said, what are you doing there? Why would he have that opportunity? And I don't know. It feels off-putting to me.
Norfolk County is a fascinating and strange
upside down
legal place. It's very different. And that's all I can say. It's just not what most lawyers are used to, who are not literally entrenched in that culture on a day-to-day basis. And I would suggest to you, given the nature of the case, the charges and the defense, it shouldn't be at all shocking why someone like Karen would want primarily out-of-state attorneys, frankly.
Right. Now, Kelly asked, Kelly, if Chloe bit, you must have quit. Thank you so much, Levy. Asked, is Bev running out the clock for the motion to dismiss so that she doesn't have to do the evidentiary hearing? I think that's a great question.
I don't know if she's running out the clock, but I mean, there's clearly not going to be an evidentiary hearing for the simple reason. I've done those hearings. It's kind of a prominent part of my practice, or either wrongful convictions or major discovery violations that can blow up a case before it ever gets tried. And they have made a very good showing that warrants a hearing, particularly because the prosecutor has no real response. And sworn, never mind that like three-headed affidavit that says nothing. It doesn't even address any of the issues. And the reality is there ought to be a hearing in which both prosecutors from the first trial testify, Rafferty, the retired sergeant from the Canton police, Proctor, if he's willing, or if he doesn't assert any privileges, Buchanan, others. You could go, Brennan, I would even call based on what Lally did or didn't tell him previously. You're talking potentially an evidentiary hearing that could take a couple of weeks. And there's just no time. And the motion to dismiss, that's a motion of finality one way or the other. If the defense wins that, you pack up your bag and go home. And logic would seem to tell me that if a court were inclined to do that, you would do that before answering all of the non-finality motions that become irrelevant if you dismiss the case.
Noted. And Armor of Alessi, thank you so much. Levy says, in case of mistrial, God forbid, and let's all collectively, in the name of the Father and Son and the Holy Spirit, what's the odds? What do you think, Mr. Bederow? Which clearly we wouldn't know, but like a third trial.
Well, there's a few factors. Number one, is Morrissey gone or not? I think if Morrissey's gone, I'd say the odds are close to zero.
Okay.
Because this is just a black stain.
It's a vote, everybody. Everybody go out and vote.
So that's number one. Number two, it depends what causes the mistrial. I mean, if the mistrial is caused by a bad error or intentional misconduct by the prosecutor, then there will be no manifest necessity for a retrial. And as a sanction of that, there can't be a mistrial. The next issue is when you start getting into like potential trial number 3, now you start getting into legal arguments about whether the case ought to be dismissed. There comes a point. Issue number 4 is if it turns out that, she's acquitted, like with a published verdict this time, on 2 counts, and the third count is hung, but it's like, 11-1, 10-2 to acquit. As a reasonable prosecutor in that sense would say, we're done. I mean, that's just a message. So I would not assume, no matter what they say or what they think they can do, that it automatically means that there would be a third trial. There's a lot of moving parts and legal issues and factual issues that could come into play.
Okay. And Bite My Bits, thank you so much, Levy, said, would the Pro Hoc Vice denial be considered a structural error?
I think so. I'll let lawyers discuss that. I could, I've said this before, my thoughts about it. I think it was wrong for a lot of reasons. But, is there an argument about depriving counsel of choice, finding a conflict without making an inquiry when that inquiry was offered, finding it actual instead of potential, and, waivers were in place from both clients, that sort of thing. Look, I think it is, but that's also not my fight, right? I'm not the one who appeals that kind of thing. And again, realistically, if they're appealing that ain't good.
Okay. And KP, thank you so much. Levy says, I find myself often wondering why the defense doesn't go harder in court when Hank is so shady. Is there a strategic reason to hold back at this point in general?
I don't
feel like they're taking off the gloves now.
I don't agree with that. I mean, I understand that it may come off as that, but when push comes to shove, in terms of zealous advocacy that is both forceful and in the best interest of either side, I'd put my money on, Alan, David, Bob, Liza. I wouldn't worry about that.
Yeah, agreed. And Marsha, animal lover.
Videos in the past. This is not new. Their elbows are plenty sharp when they need to be.
Yeah. And Marcia C., thank you so much. What are the chances they file a complaint on Judge Bev after the trial for judicial misconduct?
I wouldn't know, and even if I did, I wouldn't.
Yeah, right. But thank you so much, Lovey. And if he knew, he couldn't. No one would talk about it anyway until afterwards. So
I have no idea. I don't know.
Yeah. And Rainy Day said, "I'm sorry I'm late to the party. Have we seen the first search warrant for Karen's phone? Does it include a date later rather than 129 when it was seized? Sorry if already discussed. Love you both." I haven't seen a warrant. I haven't seen shit regarding using that.
One of the things about getting, if the right word is interested, or getting schnookered into this whole thing, too late was, right around the time of the first trial. My recollection of the testimony is they just went down there and said, we're towing the car and we're taking the phone. And how in the hell that was permissible under basic Fourth Amendment. And I don't know whether there were motions to suppress and hearings. Well, was it on
129?
Hold on. You got to dig deeper than that. Is that a warrant to seize the phone, or to seize it and also search its contents? If they had a warrant to seize the phone, then you just go down there and you say, give me the phone. That's that. My recollection is that they just went down there and took the phone on January 29th, and they towed the car also which is also a seizure, which kicks in the Fourth Amendment. And if they didn't have a warrant to seize the phone, not search it, seize it, then.
So what did they have a warrant for, babe? If they did, if you're saying that they didn't have a warrant to seize it, then they couldn't have a warrant to search it.
No, their claim, this is the whole point, which is you don't need a warrant literally in every situation to see something. If you have probable cause used in a crime or whatever, you just take it. But the easiest way is also consent. If you agree to say, take my phone, the problem is when you look at the testimony of Proctor and Buchanan, you watch it. I don't think there's any discussion, as opposed to them and their arrogance just saying, we have to take your phone. That is a seizure. And if they did that without probable cause, that all should have been subject of a motion to suppress, and anything found therein should be suppressed. And then anything that derived from that as poisonous fruit. Same issue with the car. I mean, by all accounts, they just went down there and took it. Now, could they argue if they had cause to do that? You can't just take a car like that. But if there was a hearing about why they thought they had cause at a hearing, as the lawyers tried to establish with someone like Proctor, why do you think you had cause? They would have been in a position to grill him and say, what did you see? What did you see with the taillight? Oh, I saw it was cracked. Well, naturally, you must have taken a picture. No, da-da-da-da-da. So to this day, and I haven't gone back and done the research, and I just don't have, frankly, all the time to do that.
Right.
To this day, I still don't understand how the hell on January 29th, these guys just marched down there and on their own whim, caprice, and subjective belief that we had cause to do so, said, we're walking out of here with your phone and car. I will never understand how that happened.
Right. And Pro Gamer, thank you so much, says Brennan is only trying to discredit the defense with ridiculous details to be able to pretend the CW really did have a solid case after dismissal or not guilty. Only if Proctor, scapegoat, hadn't sabotaged the investigation. Ooh, Pro Gamer, I find that feisty and I like it. Good comments. Tom CPU, thank you so much. How are you? Happy Saturday, my friend. Two amazing people sharing their Saturday with us. We are grateful and blessed for these two people standing up for the truth. Oh, Tom, you're an angel. Meatball Morrissey, Sketty Stain, hi Lovey, says Mr. Alessi's organizational skills are exceptional. He makes me want to be a better person. I thought it was entirely tacky what Auntie Bev did the other day. I feel like I think that clearly Meatball Morrissey Sketty Stain is referring to are you going to tell me what you're going to tell me and then tell me? Larry Legend, one of my friends from Twitter, said he thought that he kind of felt it was more like a Bev trying to banter Judge Canoni. And I mean, I don't think that was the time for the banter, but I know that she does, in my opinion, respond better to Mr. Alessi than let's say Alan Jackson.
I agree with that. Whether it was banter or not, I don't know. Either way, it's probably, again, the whole world is watching, and many people, obviously, if you look online, they have a perception about the courtroom and if it's swaying, tilted in one direction. And I just think those kind of comments don't help that.
Agreed. Piney Woods, Law and Crime, hi Lovey, says my two favorites. Hello to the chat and to these two amazing commentators. At this point, even if Ms. Reed is guilty of anything, she should go free. I think she's actually and factually innocent. Thank you for being here, Piney Woods. And Onomatopia, I'm sorry. Thank you so much, says last night we got a spaces and today Mr. Bederow. Thank you. You're very welcome. Freedom Ring says, my theory, oh God, I don't know. What does that mean? BH?
Behind, I think.
Behind recent defense statement in doc regarding we didn't pay for ARCA. Defense is using prior something. Response for opposition. Okay, from last year, saving with new name and adding new stuff, forgetting that certain info superseded. Oh, that's smart.
The bottom line is it's an oversight. It happens. I mean, to find that was an intentionally misleading comment, I thought was profoundly unfair and just not right. I mean, again, this is so critical to this point. No lawyer who does this for a living at a high level and understands how trials work and how witnesses work and how credibility works, there isn't a lawyer dealing with ARCA as their witness who would give a flying shit that $20,000 was paid to them after trial. There is no reason to care about that. It is completely meaningless. That's not the kind of evidence that you hide and then intentionally and then lie about. That just makes zero sense.
And then turn it over and then you get admonished for it. It's unbelievable. Right. Michelle Littlefield, hi Lovey, how are you today? Says, how did you come in possession of the emails from Traub Julie about the hostage video?
They're public. They're on the internet. There's all kinds of
on the World Wide Web, babe.
There's a whole list of emails related to that and about the dissemination of the video to various media and other, so-called media or online presences and things like that.
Kelly, hi Lovey, says it makes more sense to me that Jen and Nicole being related to Kevin Weeks, especially with Hank being hired. Kevin Weeks from Whitey? Oh, I didn't think that they were related at all. I don't know. I have no idea. I have no idea about that, but wow. Shameless Justice, thank you so much, says you are amazing. Thank you, Kim, for being an angel nurse. And thank you for being here, my little Shameless Justice. Ms. Holmes, 66, says in the Penny case recently, which I followed, not as much as attorney Melanie Little, but I thought Judge Canoni did a great job. Canoni let the family of defense sit where O'Keefe's family sits now. Why not for Reed's? Huh.
Don't know.
Maybe we could file I don't know. If the defense. Oh. Okay. Thank you. I don't know. I could follow up, but I have no idea.
It's interesting. And again, I'm not going to get involved in a fight over who sits where in the closet courtroom, but obviously, in any case, the alleged murder victim's family is going to get high priority and treated in a way that, other members of the general public won't. I mean, they lost a family member. They're going to get treatment. The issue that can become messy is if it starts to get into something that potentially prejudices the defense or impacts the defendant's right at trial, that has to take precedence no matter how people may feel uncomfortable. And the issue here is, you've had witnesses in this case show up and stare down jurors and had at least one juror say, I didn't like that. That made me feel uncomfortable. Point being, if you have to protect someone in the courtroom, the defendant always has to be number one. Now, I'm not suggesting that they're going to want to fight that fight for the optics and whatnot, but if there is an issue with people staring down the jury, that is a point that hypothetically could be raised, but I doubt they'll do that.
You know what else I did want to say for Judge Cannoni, just in general, with another case that actually went to mistrial. Cindy Chesna, the wife of a Weymouth police officer, in the Emmanuel Lopes case, I felt it was a bridge too far when Judge Cannoni told her that she was unable to show emotion, she couldn't cry, and then yet in Commonwealth v. Karen Reed, we all saw the extensive emotions that the O'Keefe family had felt throughout the entirety, and that is sitting right across from the jury. Is that typically a rule that we would see? Or I know that she used it in specifically the Chesna trial. What do we think that there is not that kind of, let's try to keep everyone on the same page? Because if you see maybe the defense and Karen, who is fighting for her life, stoic and, maybe turning around to her family, and then you're looking across and seeing, this grieving family for 9.5 weeks in front of you, could that subliminally even affect a jury?
It could. It's not that common to see a judge in advance of a situation tell a particular person, don't be emotional. You may have judges who say, look, I don't want any outbursts, but yep. I don't know how you tell a witness or someone connected literally to not emote when it happens. And I mean, look, people are real people. It gets emotional in there. To me, that's a little odd to literally tell the wife of a murdered police officer, I don't want to hear it in so many ways. Obviously, she wants to protect the defendant's right to due process and not generate undue sympathy. But the reality is it's human life. Some cases are more emotional than others. Some are more potentially offensive than others, the conduct alleged, and you get emotional, you get sympathy. And no, I think that was a strange direction to one particular person in that situation, as opposed to, I understand that this is a, emotional case. Let's all try to control ourselves. And you would say that generally, not to one person.
Yeah. Lori Marie, thank you so much. Lovey says, during trial, can the defense use dishonorably discharged when referring to former trooper Proctor?
That's the finding. So
that's him.
That's what he is. He's disgraced, dishonorably discharged, former trooper. It will not be pleasant for him. And this time it's with finality, with specific findings, including that he was biased in this. And he's just, if he does testify at the second trial, yeah, he's going to have to face a lot.
Yeah. And J.R. Cuber says, Mark, can you anticipate actual Lexus expert and Google data expert and BH and BA phone records from cell phone providers?
I guess you'd have to look at their witness list. I don't know. I mean, I haven't
Yeah.
studied the witness list, but I don't know if that's on or not. If it's not on it, I would say no, I wouldn't expect it.
Okay. And then we have a Team Wicked Smart versus Pure Wicked. Thank you so much. Levy said, thoughts on calling Kevin? I somehow keep forgetting about him because he didn't testify. His connection explains the CPD involvement cover up much better than Brian.
So I have a lot of thoughts about that, but unfortunately, I'm not going to share them. Sorry. That's
okay.
Want to keep what's in the public record and those guardrails I've talked about before. I don't. That's something.
Yes, we're not going off. Yes. And Love a Romy with cheese says, can the defense use the Annie Dukin scandal as case law to allow Easter to testify? It notes the critical role that expert witnesses can play in evaluating and challenging the integrity of investigations in Massachusetts criminal cases.
Well, yeah. I mean, if it's precedent that supports your position when you argue, you can absolutely, use whatever precedent you can to try to persuade a judge. So, yeah, I mean, if that's being argued and briefed, I would definitely. I mean, that language is helpful. I mean, that's what you're trying to do.
Okay, thank you so much. And then I'm so sorry, Mr. Bederow, we're almost there. Freedom Ring, Mark, could judge's strong reaction to the defense's Rule 14 violation be a setup for later granting their motion to dismiss? Commonwealth, you know how strongly I take the lack of candor and discovery violations. Is Bev playing the long game?
I don't know, but again, if you accept everything at face value, logically, the issue with ARCA, if you believe it is a Rule 14 violation, is as ticky-tack, non-material, early disclosure, so there's no prejudice. It doesn't matter. There's really no harm if you even believe it was a violation. The issue in the motion to dismiss is a disgraced, dishonorably discharged trooper who is the lead investigator, who has been thrown under the bus by the prosecution, but they are responsible for his behavior, who apparently found all this important video and just stuffed it in his back pocket and didn't tell anyone for 2 years. And then when he did tell anyone, the DA still inexplicably turned it over piecemeal before, during, and even after trial, all of which was material and relevant and prejudicial. So if you're going to go by the standard of what she said about ARCA, the problems that the defense has raised in the motion to dismiss are 1,000 times more egregious, 1,000 times more troubling, 1,000 times more prejudicial, 1,000 times more intentional. And if we're going to talk about lack of candor, I mean, I don't know how you do this. I don't know how you do this without a hearing, because again, it's a motion to dismiss. And if there's intentional misconduct, the argument for dismissal is greater. If I'm a judge, I want to hear from Proctor and say, explain to me why nobody got this for 2 years, because that's probably intentional. And I want to hear from Lally and say, whether I believe that, maybe Proctor says something different. I don't know. But lead prosecutor, lead investigator, and in 2 years, the lead prosecutor has no idea that there's any video, something doesn't compute. And worst case scenario, if you get that testimony, even if you believe the DA literally, meaning the prosecutors, didn't get the video, all it's doing is establishing Proctor's intentional misconduct. Because I can assure you, he has no explanation. If he took the effort to get the video and he's talking to Lally all the time, they're looking for stuff. They know the car was in the Sallyport. They know there's this, and he never discloses it. And by the way, he's on the video kind of standing around the right rear taillight, even though the video that they got was flipped. What shocks me is that a judge would not say, bring them all in. And I don't care about April 1st. I need to know what's going on here.
Yeah.
This screams for an evidentiary hearing on a motion to dismiss for discovery and Brady violations pre-trial as much as any cases I've seen.
Agreed. Like, yeah, it's mind blowing. Emily says, Sir Bederow, many feel powerless watching Bev pretend her bias isn't showing. Is contacting the CJC an exercise in futility? If so, why do they exist?
I can't advertise or recommend what people do. I mean, these commissions exist. I'm certainly not advocating or disadvocating, but I mean, people complain about lawyers, people complain about judges, and things happen or don't happen. But I mean, those committees exist in every state. I mean, that's true.
Yep. And Lola, the good dog, who is, I believe, named after your good dog, Lola. Is Lola with us?
Nope, not usually. She's underneath. Nope, she wandered out. Okay.
She said, I'm done. I hear Nurse Kim in her big mouth. Love starting my Saturday with two of my faves. Mr. Bederow, did you watch the interview with Ronnie the juror? Anything stand out or surprise you? Distractors not trusting ARCA?
I mean, a lot. I guess a lot surprised me. I mean, I'm not going to be critical of anyone, but if there was an issue where certain jurors wanted to contact the court to be heard on a clarification on the legal instructions, and the foreperson says no, and they just decide to let that go, that makes no sense to me. You need to do that. And it's also stunning for the simple reason that when somebody becomes the foreperson of a jury, that's a figurehead position. Somebody has to be the man or woman who communicates for the jury with the judge, other than and to basically say, okay, let's start doing this. Like, that's their job. They, it's like the person who sits in the exit row on an airplane. Somebody has to do it. Okay.
Mm-hmm.
The foreperson gets no special power or position of influence to basically say, I'm not communicating with the court, so too bad for you. And that's kind of, if I recall correctly, the way he described that interaction, that he just said, I don't want to do it, so we're not going to do it. That's crazy to me, if that's true. And it's horrible, because if they did contact the judge, who knows if that whole issue would have been resolved differently with the acquittal versus hung jury fiasco.
Noted. And I apologize, Lola, the good dog, that your dog is Lola too, and all Lolas are good dogs. And I think that all dogs go to heaven. Thank you. Now we're cruising along here, and I am going to say, this is not possible, right, Mr. Bederow, that jurors get quizzed of how well they understand reasonable doubt and when you must, by law, vote not guilty.
No, you can't question jurors about anything other than, is that your verdict? And you see, it's called polling a jury. Usually you see at the end of a case, and they all say, yes, my verdict was guilty. And then, you're hoping for the 1 in a million chance. Somebody says, no, not guilty. And you're like, what just happened? Yeah. But no one is getting into the inner workings, what was going on in the jury room and what they thought. And that sort of thing is kind of off limits.
Yes. And orphan methodology. Thank you so much. Levy said, I heard something called young blood. Can you explain why they might not be using this?
In what context? I'm drawn.
I don't know orphan methodology. Tell us. Ask us again, Levy.
Are you talking about like alcohol testing? I mean, I'd have to know more. I mean, there is a young blood case that relates to alcohol. I'm not sure if that's what she's talking about.
Just Joe, thank you so much, says, after the three names at sidebar, Hank looked shaken. LM was comforting him, rubbing his back. Anyone else see?
No.
Oh, I didn't think Laura McLaughlin was comforting I haven't seen her, but maybe. Yeah. And Mama She, thank you so much, says, I just want to say hi, happy Saturday, and love you both. Thank you so much. We love you too, Mama She. And Kimberlina has been a member for 2 months consensually. Hanky Panky and Bevy Bev are digging a deep hole. That is a comment, and I think that I agree with you that I hope they're. You know what I was thinking though, Mr. Bederow, is that I feel like we are in better position for 2.0 than we ever were in 1.0 because we didn't know what we didn't know. And now to see where the cookie has crumbled, i.e. Sallyport video continuing to just reveal itself for 3 years, Trooper Michael Proctor not only having an internal investigation, but being dishonorably discharged from Mass State Police directly related to his conduct in this case. I mean, and then plus everything else that I'm just saying, those are the two huge standouts to me of, I don't know how you overcome that if I was the Commonwealth.
Well, I guess, I mean, look, you have to go to the dance with the one you brung. I mean, you have to deal with what you have to deal with. Might they not call Proctor? I suppose they could think about that. But, by not doing that, you're exposing yourself to just getting bludgeoned by the defense for that. But if you do call him, because you have to also, it's not just that he got fired. As bad as Proctor was, say, 4 weeks ago, since then, he's been fired, which makes him 1,000 times worse. But don't forget something else. It's actually 5,000 times worse. He has become the patsy for explaining the Sallyport. They are pinning it on him and conveniently a retired sergeant. How convenient. But the point is, they have thrown kerosene on the fire to the defense argument that Proctor is corrupt and was up to shenanigans. Because on top of everything else, they're going to bring into evidence at trial that the video was all messed up and da-da-da-da-da, and lo and behold, it was Proctor who had it.
Yeah. Okay.
How are they going to explain
it? Well, doesn't that even look worse? Like, you're absolutely right. Like, you're saying this is the $1 million question. Because
I mean, I think it looks their only approach, the only approach they can take, if you don't want to call him, is just call him a distraction in the sense that they think they have the science, right? They have all their, I don't know that they do, obviously, but if they think, oh, we can prove scientifically the car went here at this time and he went there and da-da-da-da, and it has to be, then they just throw their hands up and say Proctor is just a distraction. If I were trying this case as a DA, well, first of all, I wouldn't try this case as a DA because I don't think it ought to be here. But if I had to, I would nuke Proctor as the prosecutor. I would just disown him and say he's an embarrassment. It's disgraceful. I'm wearing the white hat, but I'm also going to say, but let me tell you why that doesn't matter. Okay, it's a distraction. And he got what he deserved because he did inappropriate things, but he didn't compromise the investigation, that kind of thing. So that's
Sallyport. Right? Yeah. Like, because you can't get around. That's not text, and that's not like outreaching and trying to change the opinion of a medical examiner. Like, even though you tried to, strong arm her, in my opinion, 2 different times, you went for a meeting with her and she still wouldn't give you that homicide designation.
They tried to influence her so they could make a murder case. No question. And of course, now they want to keep out, her undetermined finding, which is another example of, we want the truth, the whole truth, except the truth that may not help us.
Right. And Christine says, thoughts on Attorney Yannetti's reveal that his whole file was asked for. Loveys, we're wrapping up. So I love you so much. I'm not going to be able to get to, I can do like 3 more super chats. So we have them all in. Mr. Bederow has been here for 2.5 hours and we've got Saturday afternoon plans.
I don't read too much into the feds subpoenaing the file other than they've had to listen to all this nonsense about ARCA and all these claims being made and listen to this suggestion that somehow the feds and defense have been in cahoots. I mean, that's an embarrassing argument, by the way. So it wouldn't shock me that they want to see everything that the defense has. And, maybe there'll be some pushback from them on this. We'll see.
Yeah. And Kate says, could the email between Julie and the district attorney's office be used as evidence that the Norfolk district attorney's office needs to recuse themselves from the Karen Reed case in general?
I mean, look, obviously that's for somebody else to figure out. It is highly, I mean, look, I know that Karen's team years ago made a stink about that ridiculous statement that was disseminated by Morrissey back then. There's no way around it. It's not proper to literally do the statement, but use input from actual witnesses and parents of actual witnesses to help formulate and add suggestions through the police department, through the DA's office for public dissemination. So, that's for somebody else to decide, but that is not a good look for the DA's office.
Totally agreed. And then Lola the Good Dog said Todd McGee rather would be an excellent witness to give the insight from a proper, right, Mass State Police procedures, since he was Mass State Police. Concerned Bev may not allow Easter since he's FBI and no mass case law, because she always, mother of God, her and the mass case law, like you can't cite another state ever. Thoughts on that? I think that's a great idea.
I mean, Todd, I like.
Todd's incredible.
I know he's like as good state police as it gets. To be honest with you, I don't know crime scene wise if he is qualified. I would say, yeah, that's the guy for sure. I don't know what his role and all that was. As far as why wouldn't she allow an FBI agent? Depends. Does he have the proper experience? There's no, just because you're a federal agent, if the guy's qualified, he's qualified. Now, I don't know how many crime scenes or homicide scenes or that he's handled. I mean, if the answer is like 3, then, that's a problem. I also don't know his full history. I mean, did he start off as a state police officer before he went to become a Fed? Don't know.
Yeah. He was Mass State Police forever, right? Todd, yeah.
Todd, yes. I was talking about the FBI agent. I just don't know what his background is.
Oh, I don't know that either. I'm sorry. I apologize. Okay. I appreciate you. You're the best that ever lived. I thank you. You are my friend. You are an incredible resource. You help us just calm our bodies when all of our brains are going. You are a teacher. You are just the best. That's all. I wish you a great rest of your day, Mr. Bederow.
Okay. We'll talk.
Thank you for joining me on a Saturday.
Take care. Bye.
Bye. All right, loveys. I'm so sorry. I just got to rock and roll. So you are the best. I love your faces, and I'll talk to you soon. Bye, guys.